Hello, everyone. I'm Dr. Apryl Alexander at UNC Charlotte's Violence Prevention Center. Today, we're going to talk about challenges and opportunities in addressing the competency crisis. We'll spend some time today defining what competency to stand trial looks like, also describing what we mean when we use the term competency crisis, define what the legal issues are surrounding competency to stand trial across the United States, and then hopefully provide you with some solutions or takeaway messages regarding this crisis and what different states can do to address it. So for a little background, competency to stand trial refers to a minimum legal standard that was established in 1960. This was through the landmark case of Dusky v. United States that helped us to define what competency to stand trial looks like today. Competency is defined by two different prongs: rational as well as factual knowledge in understanding the proceedings against them. So this is where defendants must understand why they're going to court, why they've been found incompetent to stand trial, and we're assessing whether or not they understand the legal proceedings. Do they understand the key players in the courtroom? Do they understand the pressing charges that are against them? Potential areas of plea bargain that might come up, and then any types of penalties that they might be facing due to the nature of their charges. When we see individuals who are found incompetent to stand trial, we often interact with individuals with severe and persistent mental illness. This may include bipolar disorder with psychotic features, other types of psychotic spectrum disorders, intellectual or developmental disabilities that might impact understanding of factual and rational knowledge, or a whole host of other issues that might impact factual and rational understanding of their knowledge. For example, this could mean individuals who are migrants or immigrants to the United States who aren't familiar with the US legal system. In other countries, they don't have things such as plea bargaining and maybe not an adversarial legal process. So for them, they might not have this understanding and could benefit from restoration, which we'll define later, in order to get a better understanding of the United States legal system. The second part is sufficient present ability to consult with their attorney with a reasonable degree of rational understanding. So are they able to work with their counsel in a way that is helpful in their own defense? So do they trust their counsel? Do they understand the role of their attorney? Do they understand that their attorney is there to help them? For instance, for individuals with psychotic disorders, they might hold or harbor delusions where they might think that their attorney is against them, working with the judge, working with the system, and might not be able to adequately consult with their counsel. So if either of these two prongs are met, an individual might be found incompetent to stand trial. So competency can be raised at any point in a person's criminal proceedings. Once this is raised, whether it's by an attorney or a judge or any other member in the courtroom, the person must be ordered to undergo a competency to stand trial evaluation. At that point, the proceedings stop. They're halted until that person does get an evaluation by a licensed psychologist or psychiatrist, depending on the state. When that individual is evaluated and they're found to be incompetent to stand trial based on those Dusky standards, most states require that defendant to undergo competency restoration services in order to mitigate the reason why they had been referred for competency. So if you're unable to consult with your attorney appropriately, getting some education, maybe even getting medication management to reduce those symptoms of psychosis in order to address that and be able to work effectively with your attorney. Once a person is reevaluated, and the time period for that can range depending on the state, and if they're found competent, they go back to their trial, the proceedings move forward, trial as normal. If they're found incompetent, they might continue with restoration until they're ultimately found competent. The reason for all of this in Dusky case was to make sure that defendants' constitutional rights were protected. We want people to have a fair trial. We want people to have an understanding of the proceedings in the courtroom. So we want to protect people's constitutional rights, and that's why we have this competency process. So I mentioned earlier the title of this talk involves the competency crisis. So what do I mean by that? A number of different scholars and advocates have talked about the widespread, substantial increase in orders for competency evaluation and restoration over the last few decades. Competency is actually the most common subject of forensic evaluations that are ordered by the courts. So, not insanity, not risk, it's all about competency. This data is pretty consistent, but the citation might be a little outdated, but approximately 60,000 individuals are evaluated annually for competency. So if we're thinking about various court systems, we're seeing these referrals quite often. In fact, about 30% of the individuals who are evaluated from that 60% are deemed incompetent to stand trial. So that's a substantial amount, resulting in about 10 to 18,000 individuals requiring competency restoration annually. So not only are people raising competency more, so that's halting a whole host of court proceedings, more people are needing to be evaluated for competency. So we're going to need providers that have training and expertise on evaluating those DUSKI standards. And then when those individuals are found incompetent, we need to make sure that they're getting the adequate restoration that they need in order to continue with their court process. So in just some examples of this, my colleague who I've collaborated with, Dr. Neil Goen-Smith, has talked about the increase of referrals for competency over time, especially in some of the states that he's worked in, particularly Colorado. From 2014 to 2016, we saw an increase in referrals for competency restoration increased by 72%. So going from 390 evaluations to 690 evaluations of defendants, and then those defendants ultimately needing restoration services. Who is providing this restoration? Well, historically, that's been done in inpatient hospitals. So again, we need to be thinking about what that looks like for individuals. So now I want to hop into the legal issues. We have this competency crisis in which we're getting increased referrals in people being evaluated for competency. And again, that 30% of those referrals being found incompetent to stand trial. So we have this bottleneck of individuals who are in need of restoration. This has resulted in a number of different legal issues over the years because those individuals often need to go to an inpatient setting, typically your state hospital or any type of inpatient psychiatric hospital that offers competency restoration. And at that hospital, they might be there for a short period of time, depending on how we can offer the competency restoration. But what we're finding is some individuals need much longer periods of time in order to be restored to competency. For a person with a psychotic disorder that has been long-term, that might be medication resistant, they could be in competency restoration for months. If we think about an individual who might have symptoms of dementia, whether that's Alzheimer's or vascular dementia, those memory problems might be long-standing. So we're having an issue where there's bed space problems in our state hospitals, in our inpatient facilities, and individuals who are being found incompetent to stand trial might be taking a long time to get restored to competency. That means that if those beds are filled, other individuals are waiting for those beds to become open in order to receive their competency restoration services. Where are those people waiting? Well, some of those people might be waiting in jails. Again, the whole competency process centers around protecting people's constitutional rights to a fair trial. One of those rights is a right to a speedy trial. So if that person is waiting on bed space for weeks or months on end, we might be violating their right to a speedy trial by not being able to find a bed for them in order to get services. So this has become a real big issue in a lot of our states, that inpatient bed space is limited. We don't have many competency restoration services for individuals, and we have individuals waiting way too long in jails, in community, for them to receive services and for their trials to continue. So states like Arkansas, California, Colorado, this new article from April 2024 out of North Carolina showing that there have been several class action lawsuits filed due to defendants waiting too long on those wait lists for competency restoration services. There have been some high-profile cases across the United States that has helped to inform some of our work. In this first one of Terry versus Hill, they ruled that individuals ruled incompetent to stand trial should not be held in jails unless there is legitimate goal. Again, we have to remember a lot of these individuals who are seeking competency services are pretrial. So they haven't been convicted of a crime yet. They could be innocent or found innocent eventually. But again, those trial proceedings had to stop until they can get competency restoration. So some people argue, could we be holding innocent people in jails for prolonged periods of time while we're waiting on bed space? That's a violation of their rights. In one of the key court cases regarding this issue, True Blood versus Washington State, they were trying to find ways in order to address this competency crisis. How can we make sure that we can get people competency restoration, in jail competency evaluations quickly? Because with all of these referrals increasing, individuals are waiting a long period of time to even get their initial evaluation to find out whether or not they're competent to stand trial. There's even been some skepticism that maybe some attorneys are raising competency in order to delay trial proceedings. I don't think that's the case at all, but sometimes individuals are concerned about that slowing down court processes. So in True Blood, they said that evaluation needs to be completed within 14 days. If a person is then found incompetent to stand trial and then needs restoration, restoration services need to be initiated within 7 days of a court order. So this whole case was trying to kind of speed up the process in order to make sure people are being evaluated quickly. Now, you see over to the left, we have an article that talks about maybe continued violations of some of these policies, or again, people still being on the wait list way too long. With some of these court cases, there are some fines attached to the court cases. So every day a person is going without getting their restoration in that 7-day period, the state gets fined. If they are not getting their evaluations within 14 days, the state is getting fined. And some of these fines are starting to rack up a lot of money for states. And so again, we need to find solutions to this competency crisis. So what are some of those solutions? I'm not going to have all the answers today, but again, we're trying to think critically on how do we get people competency restoration services that might be outside of the systems that we've traditionally done. And then also thinking about some other factors that are going on within community and community mental health in order to address this competency crisis. So first, this is an article that I wrote with a team of colleagues talking about competency restoration and the settings in which they are conducted. Again, we reflected on historically, competency restoration was offered only in inpatient settings. So once again, either state hospitals, which a lot of states only have one state hospital for the entire state, and again, not enough beds, or other different inpatient units at different hospitals in the states. Does that need to be our only option? Are there other ways that we can deliver what's mostly psychoeducation to defendants in order to restore their competency? Is there a way that we can get individuals access to that medication management they need in order to restore competency? Can this just be a given the waitlist problems and legal challenges that we have, that we're going to have to think about something else? So there have been solutions offered that are delivering competency restoration outside of our traditional state hospitals. One is jail-based restoration. So again, if people are waiting in jail settings for a bed space to open up at the state hospital or at an inpatient unit, could we give them the restoration there while they're waiting on bed space? Or again, maybe this is a person who doesn't meet a severe threshold of impairments and doesn't need to be at the state hospital and could be managed at a lower status of care. So let's make sure that they're getting the restoration services that they need while they're in the jail setting. So there have been jail programs that have been created to do this. This has been seen as a continuum part of their jail-based services, that individuals with severe mental illness might already be in different housing units based off of their mental health history. They might be receiving therapeutic services, medication management, case management already. So can we add this to their repertoire of services that once or twice a day they're receiving their competency restoration as well? So there are programs, again, I reference Colorado a lot because that's where I lived for 6 years. Colorado has had the RISE program for 10 years, offering that jail-based evaluation and restoration for individuals, serving almost 2,000 people to date. So we have programs already doing this as a part of that continuum of care. Again, there's been some controversies regarding jail-based competency restoration. Again, these are individuals awaiting trial. Like I referenced early, they may or may not be guilty. So why do we have them sitting in a jail? So some people have some ethical, moral issues regarding the delivery of jail-based restoration. And then also jail settings are not always conducive to positive mental health. They're loud, noisy environments. They're overcrowded. They put people at risk of re-victimization. So there are still some controversies in the establishment of these programs. What about outpatient competency restoration? Can some defendants get their restoration services in the community in a place that's not inpatient and be fine and successful in community? So actually 35 states have it in their statute that they can offer outpatient competency restoration, that's been written there for quite a period of time. But what was found years ago is only 16 states had those formal outpatient competency restoration programs running. So while more states allow for its use, not many states are actually taking advantage of this as an opportunity to deliver outpatient competency restoration. Again, this could be for a number of reasons. Some reasons I've heard is, oh my gosh, we're going to put this person out on the streets. They're going to be in outpatient community care. Are they safe? This could be something that could be evaluated during the evaluation process to see if they are high or low risk. We have individuals with misdemeanor level crimes who are deemed incompetent to stand trial that could be managed successfully in the community if we provide them supports and receive that restoration in community. So we've seen the rise in the use of outpatient competency restoration in a number of states, including Colorado. So that's where Neil Goen-Smith and I met in running the Denver First Outpatient Competency Restoration Program in Denver, Colorado. It was originally the first outpatient competency restoration program in Colorado, the first university-based competency restoration program in the United States, where we trained our graduate students to deliver competency restoration for outpatient individuals, again, who are low risk and can get those services in their community. Several years ago, around 2017, 2018, Colorado opened it up to have more individuals in the community offer outpatient competency restoration. So we were seeing a number of different community clinics offer competency restoration services. Individual providers who had specialty training in competency restoration provide outpatient restoration services, and that has grown. Then in 2020, Colorado actually passed a law as they were doing a number of different reform efforts to mandate that outpatient restoration be considered the default setting. So as a person is doing their evaluation, or as a psychologist or psychiatrist is conducting an evaluation, you should be by default thinking about outpatient restoration. And that the evaluators in their reports have to provide rationale for inpatient restoration. Why can't this person have their needs met, be successfully managed in community? Why do they need a higher level of care? So this followed other states like Virginia also has a similar statute there of really thinking about outpatient first and then having to provide rationale or justification on inpatient for a particular defendant. Again, it'll be nice to kind of see how this rolls out in the years to come as we continue to do program evaluation. But a lot of the work that we've seen has been quite successful, and individuals can be successfully managed in community and be restored to competency, and even quicker than maybe if they had waited on bed space in an inpatient facility. We also need to be thinking about access to resources. So it's important for us to continue to think about the underlying causes of this competency crisis and why people are being found incompetent to stand trial to begin with. Again, a lot of this comes from individuals with severe and persistent mental illness, individuals with intellectual disabilities. When we're thinking about the criminal legal system, we're seeing a rise in the aging population. So we're going to be working with older adults who, again, might be susceptible to things like Alzheimer's, dementia. We'll also talk about traumatic brain injury. So we need to be thinking about the scope of the different types of defendants that we see and what their needs might be. So when we're thinking about outpatient restoration, there's going to be other needs that the person has in order to be supported in that type of outpatient competency restoration. So first, we need to be thinking about housing assistance. When we started seeing defendants at the Denver First Outpatient Competency Restoration Program, we probably had a third of them who were unhoused. So for a while, we were having trouble getting those clients to restoration because we simply couldn't find them. They were unhoused. They didn't have consistent cell phones. Transportation to our clinic was an issue. So that's why I have transportation assistance there. So thinking about individuals having to navigate the metro system or bus system, that can be challenging for anyone, but definitely for somebody maybe with severe and persistent mental illness. So we're going to have to address those underlying issues. And as Colorado had faced its own series of lawsuits and they were getting fined, they started giving those fines back into better care and treatment for individuals who were in outpatient restoration. So after the first or second year of our program being funded by the state, we were getting people bus passes to come to us in restoration. They were getting case management, and some of those case managers were bringing them to services, so eliminating that transportation gap. Thinking about medication management. So people who are low resourced, individuals with low socioeconomic status, they might not be consistent with their medications. They might not be able to afford it. So being able to make sure they have access to adequate medication management through case management. And then any type of other supplementary therapeutic services a person might need, again, thinking about all the underlying challenges to why a person might be incompetent to stand trial, and making sure that we're offering those supplemental supports as well. So when you're coming to competency restoration, you're often just addressing competency. We're not addressing some of the underlying mental health issues. So making sure that they are seeing a psychiatrist, going to a therapist in addition to the competency restoration, because competency restoration is solely for competency. So again, with that access to resources, just thinking about how states are using some of these fines and fees and investing it in new pilot programming to help people on the wait list. So again, this is an article from 9 News in Colorado and Denver talking about how those fines and fees were being used. And at the Denver First Clinic where I worked, they're now piloting some programming on how to address individuals with traumatic brain injuries. We know that upwards of 80% of people in our criminal legal system have traumatic brain injuries. Some people are baffled by that number, but it is that high. Whether it's people who had injuries due to sports, car accidents, assaults that they faced, abuse, it's upwards to about 80% or more of individuals in our jails have faced some type of traumatic brain injury. So perhaps our competency restoration process needs to look differently for those individuals. They might have trouble with being able to track what's going on in the courtroom, and maybe that's a factor that's impacting their competency. So are there ways that we could give them skills and tools based off of their impairment in order to be more effective in competency restoration? And again, help these people during their trial and make sure that they're advocating for themselves and helping their attorney to advocate best for them. So I'm really excited to see my colleagues undergo some of this pilot programming to see if we can use this as a model for other restoration programs across the country. So this comes to some of my future directions. We really need to think carefully about how to address this competency crisis. And I think on those last 2 slides, I said we really need to be thinking about the underlying issues impacting individuals with severe and persistent mental illness. A lot of our communities are facing problems largely about community-based mental health services. Thinking about we have longer than average wait times for individuals being able to get mental health care. Thinking about substance abuse treatment programs closing or not being able to serve certain individuals with complex cases or people with histories of criminal offenses. So we need to look holistically at our mental health system, our community mental health system as a whole, to make sure we are helping and aiding people before they come into contact with the legal system, before they commit crimes or even recidivate. Then again, if we're continuing to see this competency crisis right now, we have to get creative. So we need to think about how we're investing in the expansion of jail-based competency restoration programs, as well as outpatient or community competency services. So as I've been talking to people across the country, especially in those states that are not offering outpatient services but can by statute, thinking about being able to support those individuals in order to start their own outpatient competency restoration programs. There's a lot of great work being done by the Gaines Center and through SAMHSA on being able to work with states and multidisciplinary teams to get this stuff running. So really thinking critically about how do we expand these types of programs. Once again, we need to continue taking a look at the population that we're serving. We can't have a one-size-fit-all model for competency restoration services. When I originally got into competency restoration at a state hospital, you had everybody in the room and we were going over the same curriculum with everybody in the room. Again, it may or may not be effective, but people have different learning styles, people have different and varying levels of impairments, and we're going to have to make sure that we are adapting our curriculums over time. So that's where you see people like Denver First and some folks at different outpatient competency restoration programs trying to adapt our curriculum to meet the needs of our clients, particularly those with TBI or other cognitive impairments. Thinking about ways that we can incorporate cognitive remediation into our current curriculum in order to be more effective in getting them restored promptly. I didn't have as much time to talk about this, and again, it's an area that's evolving, but we do have youth who are found incompetent to stand trial. And that becomes a very tricky population because we need to be thinking about their developments and where they are on their trajectory of developments and how that plays into their being found incompetent to stand trial. For some youth, they're incompetent to stand trial simply because they're not really aware of the court system. So basic psychoeducation on how the court system works is effective for some of those youth. For the youth with other types of behavioral problems, developmental disabilities, we need to be thinking about, again, adaptations of our current curriculum in order to fit the needs of those youth. We're seeing a lot of creativity in some of the program developments. There's some folks in Texas who are trying to create games or video game types of measures in order to engage and teach them about the legal system. And so I'm really excited about what's to come in helping our youth. And then lastly, some people say, why are we finding youth incompetent to stand trial anyway? Can we engage in better diversion with these youth? Do they even need to be in the system and being held up by all of this, again, getting them off their developmental trajectory? So that's something for us to think about too, is how do we support youth mental health? How do we think about better diversion programs while still protecting their constitutional rights to a fair trial, and again, thinking about what this looks like in terms of their impact on the state or a particular victim. For our current programs, whether it's inpatient or outpatient, I still think we need to do some review of outcome measures of competency services. Again, asking both clinicians and our clients what's working and not working. Breaking down some of the variables and characteristics of who's being found incompetent or not, who's taking longer in competency restoration services. And again, this can help inform our curriculum. This can help inform how we meet the needs of our clients. That's what hops into number 2 of thinking about culturally responsive services. Again, I think one of the biggest areas I was seeing during my time in doing this work is meeting the needs of immigrant, refugee, migrant individuals who are becoming incompetent to stand trial. So depending on where you live, are we able to offer services in different languages? How do we describe that? Because again, our United States legal system does not reflect legal systems in other states. So is there even a term for probation officer for plea bargain in a different language? No, because they might not have a plea bargain process. And so, again, trying to think about how we are responding to the cultural needs of the clients that we're serving is one area of future directions. And then lastly, we just need to collaborate and talk. I'm really looking forward to our panel discussion of thinking about what you're seeing in your own communities. What are some of the barriers that individuals are facing with regard to competency restoration? What are your fears about implementing jail-based or outpatient competency restoration? I think we're all here because we're on board for addressing this competency crisis. So let's all work together on thinking about some creative solutions, talking to everyone in the system, from our attorneys to our judges to our providers to our legislators, about what needs to happen in order to address this crisis. So I thank you for your time. You're going to have all my contact information. And again, I love doing this work. I love doing the consulting with individuals about this work. So I look forward to having our discussion together.